Hello, I'm Vincent J. Russo of the Russo Law Group and co-host and creator of Family Comes First on CFN. This is part of a two-part series on wills, revocable trusts, and avoiding probate. In part one, I covered why have an estate plan, the importance of having a will, and the benefits of a revocable living trust. I pointed out that if you do not have an estate plan, you lose control over who inherits your assets and when, who will control the estate administration, and who will be the guardian of your minor children. We discussed how a will can ensure that your assets pass to your loved ones in the manner and amount that you want. For example, if you have a child with special needs, you want to have your child's inheritance placed in a supplemental needs trust for the child's benefit, as opposed to passing outright, which would disrupt his or her eligibility for government benefits. As an alternative to a will, we discussed that you can use a revocable living trust, allowing you to leave your assets to your family in a protective way. There are also additional benefits to using a revocable living trust. For today, we will focus in on the benefits of avoiding probate and how to do it. When you have a will, it is subject to a probate proceeding in the probate court, referred to as the surrogates court in New York State. With a revocable living trust, the court proceeding can be avoided. With a will, there can be delays before the beneficiary receives their inheritance because a will needs to be probated. During this COVID pandemic, we have seen many families waiting for a loved one's will to be probated for months as the courts were shut down or not operating with a full staff. A will is also subject to a public proceeding, unlike a trust. This may open your testamentary plan to be seen and commented on by strangers. There are also costs involved: court filing fees, bond fees, if applicable, and attorney fees. Lastly, it is easier for someone to contest a will than a revocable living trust. There are two grounds for contesting a will. One, that you lack capacity at the time you signed your will, or two, that you were unduly influenced. With a trust, it is much harder to successfully make these arguments. Also, when you probate a will, you have to give notice to certain individuals who then have the opportunity to contest your will. You give them a forum to do this. This makes the process more complicated and costly. With a living trust, there is no requirement to file the trust with the court, and the court does not need to approve the trust or appoint the trustees. Your successor trustee can step right in and administer the trust without delay, including distributing the assets to your beneficiaries. So, how do I avoid probate? The key is to have your assets pass outside of your will. There are three ways to achieve this result: joint ownership with right of survivorship. For example, many couples own real estate, tenants by the entirety, which means when one passes, the surviving spouse is automatically the owner of the property. No further legal steps need to be taken. Also, this can be done with joint bank accounts with right of survivorship. Another way is by beneficiary designation. For example, naming your spouse or child the beneficiary of your life insurance policy. Lastly, by creating and funding a revocable living trust. The question I am most asked is, when does a revocable living trust make sense for me? Let me share a number of situations where I would recommend a revocable living trust. When I want my family to have quick access to my assets. When I want to save legal fees and court costs associated with probate. When I want to avoid two probates because I own real property in multiple states. When I have a family member who will likely challenge my estate plan. The key is to have an estate plan that makes sense for you, that meets your objectives. The first step is to make a list of your assets, think about who you would like to benefit from your estate and in what manner, outright or in trust. An experienced estate planning attorney can help design your estate plan and then help you with implementation. With a comprehensive estate plan, you'll be able to leave your assets to your loved ones in the most protective and efficient way. Be well and be safe. This is Vincent J. Russo for CFN in the Legal Know.